gentlemen, the American Jerry and Bulldog Nation. First, I need to do a caveat about what I'm about ready to say. Unlike many of you, I have stopped watching the news. I cannot watch the same old song and dance over and over and over again from Fox News. I sure as hell ain't going to listen to any of the liberal news. And I can't stand to watch the ridiculous local news. Now, how do I stay up on the news? The news sites from my phone, because I can stay on top of what's happening without listening to all of it. So if someone has gone on a news program and told you what I'm about ready to tell you on two major issues, I apologize. But I don't think that they have, because I haven't seen either one of these pop up in any of my news feeds. And by the way, I check out all the news, liberal, local, national, conservative. All right, here goes. Many of you have asked this question on social media. Well, when can you use deadly force, and what can you protect? Well, here is the law generally in this country. Now, this comes from my work in Ohio and Kentucky, but I've also done work in about 10 or 15 other states, not on this issue. Florida, remember, I was licensed in Florida too. But here is the general rule. You can always use deadly force to defend life. You cannot use deadly force to defend property. However, like most things in law, there's nuances. You're allowed to use deadly force when you perceive your life is in danger. So here it goes. And this is what I have to assume that the business owners in our liberal cities are as liberal as their politicians. So here goes. If I am a store owner and I got a shotgun and a brick gets thrown through my window, or somebody comes through that door with a mask on that I don't know who the hell they are, I can shoot to kill. I can shoot to kill. I'm allowed to perceive a brick coming through my freaking window and somebody I don't know coming through the freaking door, is they're going to cause me harm. Blow them freaking away. Blow them away. There's going to be 8 jurors in Ohio or 12 jurors in Kentucky that are going to convict you. One of my favorite stories of all time about how you, and by the way, that old cliche, remember, cliches are true because they're true. That's what makes it a cliche. The old saying, rather be tried by 12 than carried by 6, is true. Who wouldn't? There was a woman who, this perv was molesting boys out in Ellesmere. I forget her name. I represented her. She met the guy in a van down in Covington in a parking lot to set him up. And when she got there, she took out a gun and shot him in the crotch. Blew off one of his testicles. Do you know that the Kenton County grand jury did not even indict her? They didn't even indict her. So I'm telling you that if anybody ever comes, by the way, if they're coming up the driveway in a menacing fashion, shoot them. Shoot them. I'm telling you, if really a mob is coming up your driveway to your house or your business, I'm telling you right now, you don't have to sit there and go, are they going to kill me or are they just going to wreck my house? Really? Blow them away. Your life and the sanctity of your home is just going to be okay with that. Now, I want to say this. All of these things that I'm saying as a political commentator. I haven't been retained by you to be your lawyer or anything else. I'm a retired lawyer anyway. Everybody knows that. Now, number 2. This is, remember the other video today where I'm blasting them for what reforms you want? Well, I'm going to help out all the rioters and the protesters and all the anti-cops people. Because I haven't heard one national commentator. I love bragging about this stuff because it gives me credibility with you. I haven't seen one lawyer consultant on watch. And by the way, all the news stations watch my stuff. You watch. They'll have some lawyer now tonight on the news talking about this. I guarantee you. Oh, come on, Bulldog Nation. You report back to me. You watch. They're going to get a legal commentator on there to say, they won't call me. I don't give a shit. But you watch. They're going to have a legal commentator on tonight to talk about what I am about ready to tell you. Here is what needs to happen in reform of police litigation. First, by the way, all you police officers out there, I'm for you. But with one of you screw up, I'm for them. But I have become pro-police, except when you screw up. I'm not one of these guys that's anti-cop, anti-cop, anti-cop. Now, here is something that the police benefit from, which they should not benefit from. First, I agree with the law that a police officer, when he makes a mistake, should have immunity. Come on, man. It would be a disaster. Honest mistakes deserve immunity. If somebody has a squirt gun and it looks like a real gun and they point at a cop and the cop shoots and kills them, come on. Now, the law is deliberate indifference. It's almost like, it's not really a reckless standard, but it's almost like reckless, closer to intentional. In other words, a cop who beats the hell out of somebody who's handcuffed in the back of his cruiser, you can sue him under what's called a 1983 action. Now, here's what happens in federal law. By the way, folks, I've done this countless times, okay? And by the way, in two pretty bad jurisdictions, I can tell you right now, Judge Bertelsmann and Judge Bunning, I had to reverse Bertelsmann twice in the Sixth Circuit Court of Appeals on a gigantic case that took me 10 years to win. Judge Bunning, the federal judge down here, agreed with me 100% on my naked black man case until I got a racist. Oh, wait, I think racism exists. A racist, retired 90-year-old Nazi Sixth Circuit retired judge who couldn't get past that there was a naked black man on the road. In other words, he made the excuse. He's a naked black man. Well, who cares if he's naked? He didn't deserve to be tased 30 freaking times. You see it. The facts are the facts. But anyway, a 1983 action is under the code. There's a section in the United States Code 1983. That is what the government, see, you can't sue the government unless they give you permission. True story. The government allows you to sue police under a 1983 action. Now, most litigation against cops are in federal court. All right, now, here is what happened. You file a lawsuit. This is going to blow you guys away. And again, no one talks about it. You're getting it first from me. Lawsuit. It's fine. The defense has a right to file what's called a motion to dismiss right away. So you file the lawsuit. Here's what they do. They file a motion to dismiss it based upon immunity, yada, yada, yada. The judge will take 6 months to a year to rule on that. Judge rules. Do you know that if the judge rules in the plaintiff's favor, the defense, the cops in the city or wherever they are, has an automatic appeal right? Automatic. So here's what happens. If you file a lawsuit against a cop, and even if the judge rules in your favor on the motion to dismiss, they can file an appeal to the Sixth Circuit. Then that appeal goes to the U.S. Supreme Court, decide to take it. You are tied up in the appellate system for 3 years, and you haven't even taken a deposition. You haven't done squat. Now, get this. You win that. Let's say you win the appeal. So your lawsuit comes back. Then you conduct discovery. You take depositions of cops. You get their police file. You find out their training records. You get all that stuff. You know what they filed in? They filed what's called a motion for summary judgment. The motion for summary judgment, then the judge rules on. If the judge rules in your favor on the motion for summary judgment, they have the right to appeal right away. Here we go again. 3 years. If you win that, you come back to court. You have your trial. And if you win, appeal. 3 years. It will, if they fight you to the death, your justice is 10 freaking years if you sue a cop. And guess what? They know that. Now, if you win your 1983 action, you're entitled to your attorney fees if you have a win. So, you can be mustered up. But look at the victim. By the way, again, another thing to help the lawyers out, not helping the plaintiffs out. So here is what. So now, have you heard? Help me out, Bulldog Nation. Have you heard anybody talk about this injustice? I'll bet you there isn't a single protester out there, black or white, who's had this explained to them. So all you protesters out there, put this on your list of something that needs to be reformed because it is wrong. Justice delayed is justice denied. Gladstone. And that is what goes on in every police misconduct. The case that I won, I had the verdict for the check framed around here somewhere. It took me 10 years to get $1.2 million for 2 families. Unfreaking believable. Think of what happens in 10 years. 10 years. That is a reform that needs to happen. Now, okay, 5912 and Inquirer, get on the phone, call Albert Hartstein or somebody to get them on there and explain this to you. Chuck, I've never done this before, but I'm going to do it. I think our followers can handle it. Local media.